Good morning. You're going to call the November 3rd meeting of the Ohio Elections Commission to order at this time. Mr. Executive Director, would you please call the roll?
Mr. Knight.
Here.
Ms. Hagan.
Present.
Ms. Tavares.
Here.
Mr. Lyle.
Present.
Mr. Kreitz. Present. Vice Chair Kaufman.
Present.
Chair Bateman.
Present.
All members are present.
Okay, the first order of business is to approve the regular meeting minutes of October 13th, 2022.
And I will just say to everybody, obviously, I'm again sorry for having forgotten to add it's kind of important portion of the minutes that were approved last time, but I circulated to everybody what I have included, and they are now included in there in terms of outlining the discussion that we had on the appointment of the alternate member. It's in there now, and so now those meetings should be final.
Is there a motion?
Second.
Second, there's been a motion that's been seconded. Any further discussion on the motion regarding the approval of the minutes of the October 13th meeting? Seeing none, all in favor, signify by saying aye.
Aye.
All opposed, the same sign. Motion carries by a vote of 7-0. The next order of business is the approval of the regular meeting minutes of October 27, 2022. Please direct that the executive director has circulated to everyone a revised copy this morning. So we are going to be voting on that particular version.
Yeah.
All right, go ahead.
No, I was just gonna say, I always have Chris review the minutes, and he didn't have a chance to do that before yesterday. He was out of the office, as he normally is, working from home on Wednesdays. When he came in this morning, he and I chatted about some maybe typographical changes that were made to the minutes. A couple of seconds to certain items were changed that I had listed, I guess I'd say incorrectly. But other than that, nothing major was changed in the minutes, but you have them now before you. I'm going to answer any questions if you had any.
Okay, seeing no questions, is there a motion? Is there a second?
Second.
Okay, there's been a motion that's been duly seconded. Any further discussion? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, the same sign. Motion carries by a vote of 7-0. Okay, due to appearances, you're going to take things a little bit out of order.
Do that one first. That's fine.
Okay, yes,
Yeah,
all right.
that's fine.
I see Mr. Brown, Attorney Brown is here. This is in the case of Bobby Mitchell et al., case number 2022R-424. Mr. Executive Director.
Mr. Chair, members of the commission, this was before us a couple of weeks ago. We continued it to this date in hopes that there would be a resolution. I've exchanged emails a couple of different times with Mr. Brown, in which he indicated both he and his client were awaiting word back from staff of the Board of Elections. I talked with the board staff, with a board staff person this morning, who indicated that they have not been able to review the responses or the submissions that have been made in the intervening periods. Sorry, Mr. Brown, but my inclination is to continue this again. They just indicated with the crush of the election going on, they didn't have a chance to look at anything.
No objection.
Okay. Sorry, I didn't find that out until this morning. I meant to try to call yesterday and I got doing other stuff.
Oh, it's frustrating. We've been calling them pretty consistently over the last month and haven't heard anything back from the Board of Elections or the prosecutor's office. So, but I mean, despite the frustration, I guess a continuance probably in order.
Thank you. Do we need a motion?
You can move to continue that. We want to do it for a date, so. Why don't we just say, let's do it to January, and I'm working on the agenda, I haven't finalized our schedule for next year. I anticipate having probably a couple of meetings in January. Why don't we say we just continue this to sometime in January, and hopefully in the intervening period, we'll get enough time to do that.
No objection.
and I'll be back in touch with you.
All right. Am I dismissed?
Sure.
Thank you.
Okay, the next case we have moved to express right now would be David Leland et al., case number 2022-S-001. We do have attorneys here today.
Mr. Chair, members of the commission, this is a complaint that was referral submitted by the Secretary of State's office to this, to the commission, concerning the fact that candidate David Leland, as treasurer, had two open campaign committees. Ohio Revised Code prohibits a candidate from having two campaign committees. So that's the essential nature of the complaint. We received materials from Mr. Leland's counsel, Dominic Tide, who was here this morning. I've circulated all those to you. I synopsized the nature of his memorandum. Mr. Katz is here on behalf of the Secretary of State's office concerning this complaint. My recommendation is to find violation, but for good cause not to find. Certainly, if the commission wants to hear from the respective parties, you can do so.
All right, yes, we would.
Thank you. Good morning. I am Brian Katz from the Secretary of State's office here regarding a referral of David Leland. The Ohio Revised Code clearly states each candidate shall have no more than one campaign committee for purposes of receiving contributions and making expenditures. The Supreme Court's judicial canons have additional requirements for judicial candidates, but those do not in any way allow an Ohio candidate to have more than one campaign committee at a time. The official source of guidance from the Secretary of State's office is our Campaign Finance Handbook, which has a paragraph on this with the unambiguous first sentence: a candidate may have only one campaign committee, no matter how many state and local offices held or sought by that candidate. What appears to have happened here is the committee's treasurer combined the two different ways a candidate could lawfully transition from being a House candidate to a judicial candidate. The two options are, first, properly terminating your committee and then creating a new judicial committee, or spend the rest of your House committee money and then file an updated designation of treasurer to change your office sought from one office to the other. Historically, our office maintains records based on the candidate. That way, if you're searching for contributions or expenditures for Mike DeWine, you can see the entire history of that candidate, regardless of the name changes that have happened by that committee or the different offices they've sought throughout time. Confusion regarding office holders changing from judicial races can happen. So we try to give candidates the benefit of the doubt by, instead of initially creating a second committee for them, we treat it as an office sought change. And then that way they don't have two committees open at the same time. We explain to the committee what's going on and advise them that their filing credentials will not change, so they can still do their filing the same way as they always have. And we tried to do that here, but received pushback that they did intend to have two separate committees. The facts here are not in dispute. Mr. Leland had an existing committee, then created a second campaign committee to run for the Court of Appeals. During those overlapping 3 months, the House committee made 3 expenditures and the Court of Appeals committee received 257 contributions and made 10 expenditures. While the Supreme Court's judicial canons add complexity to Ohio's often confusing campaign finance laws, the law prohibiting a candidate from having 2 campaign committees is clear and unambiguous. In light of the self-declared overlap between the 2 committees, the Secretary of State's office requests this commission find a violation has occurred and imposes the statutory fine. I'm happy to answer any questions you might have. Thank you.
Do the commissioners have questions?
You mentioned pushback. Can you elaborate on that?
Yes, so we initially just kept it as a single committee and advised the committee that it was just going to be a change from one to the other. And the counsel for the committee responded that no, they were afraid of confusion in reporting where there was activity for 2 separate entities and being confused as to which entity was actually doing that spending. From our standpoint, that's not a problem because one committee must have completed before the next one starts, so there is no confusion as to who's doing the spending. But if you were attempting to have overlapping expending, I see how that could be confusing.
And how was that discussion or position given to you? Was it a letter that was not answered? Was it agreed upon meeting or phone call or whatever? Unpack the
It's in an email.
dialogue between the Secretary of State's office and the campaign council or the campaign or whatever.
So I am only aware of the initial phone call from the affidavit provided to you by the respondent, as well as our campaign finance examiner after being told of what she allegedly told them, and which is just not, there's no way that any of our examiners who are 10-year plus examiners would ever say it's okay to have two campaign committees at the same time. So after seeing that that's allegedly what she said, had to go ask her, is there any way possible that this came out of your mouth? The second part of the conversation is the email attached as Exhibit D or E, where council pushes back and requests and explains why they want two separate committees.
Commissioners have any other questions at this time?
Thank you very much.
Good morning. I'm Don McTighe, counsel for the respondents, all the respondents on this referral. We would respectfully request that the commission decide this case based on all the relevant facts, which I will go over as quickly as I can, and in addition, all of the relevant law. First of all, with regard to the facts, I don't think the facts are really in dispute, other than for the first time I'm hearing from Mr. Katz that there may be a dispute on what a campaign finance person in their office advised Mr. Durkin, the treasurer here. But we have the sworn statement from Mr. Durkin outlining that. So the basic facts here are that the State Representative Committee existed for many years. On November 4th, that would be November 4th of last year, Mr. Leland, State Representative Leland, formed the Judicial Committee to run for the Court of Appeals. That was the first date under the Judicial Code of Conduct that candidates are permitted to solicit and receive contributions for judicial offices. So that was on November 4th. Now, he still had in existence the State Representative Committee. However, before registering the Judicial Committee, Mr. Durkin, the campaign treasurer, had a conversation with Ms. Moore Kester in the Secretary of State's office about the wind down process and about starting up the Judicial Committee. And they specifically discussed that there could be an overlap of activity because the State Rep Committee was winding down. And there was some overlap, but I think it's really important also to facts to know what that overlap was, which is set forth in our memorandum. The last date that the State Representative Committee received a contribution was September 28th, 2021. Okay. The first contribution received by the Judicial Committee was November 6th. Okay, so that was 39 days later in terms of fundraising. So in September, you have the last contribution being received by the State Representative Committee. State Representative Committee, or I'm sorry, Mr. Leland forms the Judicial Committee on the 4th of November. receives the first contribution on November 6th. On the disbursement side, the State Representative Committee made 2 disbursements on November 6th. Same date same date that contributions were received by the Judicial Committee, but the 2 disbursements made by the State Representative Committee were for 2 debts that were owed, reimbursement of expenses to the campaign treasurer, Mr. Durkin, for expenses that he had incurred and now was being paid back for. Those 2 expenses were for $91.93 and $187.50. Okay, that left a balance in the State Representative Committee of $80, which the committee then made a disbursement on December 1 to a charitable organization in Columbus, and then that brought the balance down to 0 so that the committee could terminate. Mr. Durkin waited for all the transactions to clear before formally terminating the committee, because he didn't want to have to terminate, and then if something didn't clear, go back and reopen the committee and amend reports, that sort of thing. So in terms of the numbers that we're looking at here, okay, there were 3 expenditures, okay, $91.93, $187.50, and the $80 charitable contribution, okay? There were so there were expenditures by the State Representative Committee after the Judicial Committee was formed, but those were clearly just 3 winding down expenditures, didn't incur any new debts or any new obligations. In addition, it didn't raise any more money at all, 0, after it formed the Judicial Committee. In fact, it turned away contributions. We have an affidavit from Todd Book, who was a lobbyist and attempted to offer a contribution on behalf of one of his clients, but Representative Leland, rejected that, indicating that he was now running for judge and could not accept contributions in the State Representative Committee. So the way they proceeded here was in a way that they thought was completely lawful. There was no new fundraising by the State Rep Committee. There was no new incurring of financial obligations. They simply took care of the 2 debts that were owed and disposed of the remaining $80 to charity. And they didn't raise any money through the State Rep Committee. So Mr. Durkin believed that that was appropriate to proceed in that way and to go ahead and set up the Judicial Committee, and that he believed that based on the conversation he had had with the Secretary of State's office. That is a crucial fact here, which goes to one of the defenses that we've raised in our legal memorandum. I would like to now address some of the law here. Well, before I address the law, let me address something that Mr. Katz was explaining. When the Judicial Committee was registered, I think there was conversation between an associate attorney in my office and Mr. Katz, and about having whether we were just going to change the name of the committee and the office being sought, or whether we're going to set up another committee. And it is true that the Secretary of State's office offered to say, well, we can just change the name and we can change the office sought. The problem with that is that it would have, when the report was, when you went file the report for that committee with the change of name, that report would end up overlapping both a state rep campaign and a judicial campaign. That's a problem because that report, the reporting period for that report would have encompassed both campaigns. Therefore, the committee decided that it was cleaner, actually, to work on closing down the one committee, setting up the new committee. And they did that, again, in reliance upon a conversation that Mr. Durkin had. Okay. There are potential legal questions in a committee covering both filing a report that includes both non-judicial and judicial. The problem stems from the Code of Judicial Conduct, which specifically provides that, first of all, no fundraising can start by judicial candidates till X date. But more importantly right now is that it also provides that no funds raised for a different race, for a non-judicial race, can be used in a judicial campaign. So if you file a report showing that if you raised funds, which would have been a considerable amount of funds on how far back that report would have gone, okay, covering the state rep race, there would be the potential for confusion, but also for a possible allegation of commingling of funds and then using the non-judicial funds in a judicial race. Because as we know, money is fungible. And if it's commingled, then it might be difficult to comply with the Code of Judicial Conduct. So for that reason, the committee thought it was best to go ahead and set up and we say set up, we're talking about registering a committee for the judicial campaign separate, so that the information would not be commingled in the same report. It's true the Secretary of State does have a preference for administrative convenience to have only one committee under a candidate's name and to continue to use even the same filing credentials for electronic filing. We've seen in the past that has caused some significant problems in terms of information that people see then online regarding the reports. Be that as it may, the intent here was to try to adhere both to the canons and to the state law based on the advice or the conversation that Mr. Durkin had received. In terms of legal arguments, in the memo that we filed, we have 7. But before I get to those, I'm going to add another one. Yes.
I think you're, but why you I did have one question. Candidate Leland, term limited out of state rep office again during this period of time.
I don't know. I'm being honest. I really don't remember if he was or not. I know he's been there so long. But, you know, and I don't think he's ever been a senator. So, he hasn't been a senator. So I think he may have been term limited. Absolutely. Yeah. Okay. So the referral in this case alleges a violation of 3517.081 paragraph A. And as you know, the commission's rules require that complaints, whether they are from citizens or from boards or the Secretary of State, they have to cross-reference the statutory provision that is allegedly being violated. And it does have a cross-reference. But what that section says is that each candidate shall have no more than one campaign committee for purposes of receiving contributions and making expenditures. The word "and." is what's important here. Mr. Leland did not have 2 committees for receiving contributions. He was receiving, did not receive any more contributions in the state rep campaign committee. He received contributions only in 1. Now, there were some expenditures made by both, but here the requirement in the statute that you are being asked to apply says that you cannot have more than 1 committee for both of these purposes, which we don't have under the facts in this case. Now, the other legal arguments is that the first is that there is a conflict, and I've already kind of alluded to this, a conflict between the state provision on more than 1 campaign committee and the complying with the Code of Judicial Conduct. I won't go through all that. It's in here. I assume people have read it. But what I want to emphasize here is that there is the ability of an administrative agency like yourselves, if not an obligation, where you see a conflict between the statute you administer and other statutes, to try to resolve that conflict under rules of statutory construction. The rules of statutory construction specifically state that the agency or the court, depending on what forum you're in, should attempt to give effect to both statutes to the extent that they can in resolving the conflict. We believe that there is a way to do that in this case, which we have set forth here, that the commission could find that the 2 campaign or the 1 campaign rule, committee rule, is not violated under the unique facts here, which is there were no new debts incurred. There was no new fundraising incurred by the state rep committee. It simply wound down and then terminated. All the judicial activity occurred under the judicial campaign. There was no commingling. So under these limited facts, we believe that that allows the commission to follow its obligation to construe statutes or legal provisions that conflict in a way that would resolve the conflict. So we would ask that you do that here. We also bring up the fact, the conversation that we've already discussed, that Mr. Durkin's affidavit states that he had with the Secretary of State's office. We believe, again, that's sworn testimony from him. If the Secretary of State wants to change their advice, they have the right to do that. Okay, if they want to say, no, we're not going to tell people that anymore. We're going to be very literal. If you've registered 2 committees that overlap by even a day, then you have 2 committees. Okay, we're going to be very literal. They can do that, but they can't do it retroactively. Okay, we've cited many cases here that provide that administrative agencies and executive branch offices cannot change their interpretations retroactively. Third, the Secretary's referral places form over substance. I think it's pretty apparent here, based on the facts that I've laid out, that indeed, apparently the only reason that the Secretary of State is concerned about this is for administrative convenience of the Secretary of State's office in how it manages its electronic filing database by candidates. They want a candidate that has, whoever the candidate is, they want to have 1 committee associated with that candidate's name. Okay, we've submitted the email correspondence between myself and Mr. Katz that occurred after the referral was made. And in that, Mr. Katz repeats what he pretty much said today about the administrative convenience that this affords the Secretary of State in the way that it manages its online filings. So raising form over substance is a due process issue. And there has to be a compelling governmental reason, or at least an important governmental reason. Form over substance, or I'm sorry, administrative convenience has been rejected by the courts over and over as being a sufficient justification by the government when it comes to regulating campaign finance or political speech or political association, which campaign finance is under the First Amendment. And then next, the respondents believed that they were acting pursuant to guidance from the Secretary of State. They reasonably believed that they were. So there is a concept which we discuss. It's a doctrine here more than a concept, which is discussed here in our motion, that it's called estoppel by entrapment. Okay, or you cannot, in a situation like this where advice is given, it's reasonable to rely upon it, the government can then not go after you. Okay, that is essentially a due process issue as well. But there is a specific legal doctrine that applies here that prevents the action from going forward. That's the estoppel part, based on perceived entrapment. You can't tell them it's okay, then say it's not okay, and pursue legal action, which is what the complaint does. The next, we argue the harm, which is the administrative convenience, and I've kind of rolled that into one of the earlier arguments. And then last, we want to bring up the referral sites. We say is the incorrect statutory provision, but that argument is based on based in part on a previous advisory opinion by the Ohio Elections Commission, subsequent, where the commission said that it was okay when they interpreted this particular statute, the commission said it was okay to have more than one campaign committee at the same time, because those are different candidacies. Okay. Now, subsequent to that advisory opinion, the General Assembly enacted a new legal provision in a totally different section of the law, which says that you can only have one campaign committee for all candidacies. Okay. Begs the question, though, about whether or not the advisory opinion was actually overruled, because the General Assembly did not amend the actual statute that was the subject of the advisory opinion, and is also the only statute involved in the current case. So I would ask that you consider, again, all of the relevant facts, and second, consider all of the relevant law. I believe that it is within your authority to find no violation in this instance, based on several of the arguments that I have made. I'd be happy to try to answer any questions. Okay, thank you.
Commissioners, any questions?
I do have one. Thank you, Mr. Chairman. And Mr. McTighe, I guess my question goes to, why wouldn't the candidate who was closing out their state rep race go ahead and pay those two debts and make the contribution, file a final report, and then create the new committee? I mean, if it was such a small amount left in the state rep race for the campaign committee, and they knew that there were two debts owed, small amounts, and then there was going to be $80 left, make that contribution, and then close out the committee. Was there a deadline for the candidate to file to run for that judicial race?
Well, there's a deadline, yes, to file your petition to run, but even before you get to that deadline to file your petition, you can begin fundraising 180 days before, which was that November 4th date. So, and you probably all know this, but judicial campaigns have a date the window opens and a date the window closes, okay, where they have to do all their fundraising. And in addition, they are under contribution limits that are considerably lower than, say, statewide or General Assembly. So candidates, judicial candidates, will want to begin fundraising at the earliest possible date that they're permitted to under the Code of Judicial Conduct, okay, which was November 4th. Now, with regard to why they didn't terminate earlier, it's true that they only had the 2 outstanding debts and didn't incur any more. However, there were a number of checks that had been written by the committee that were months old and had not been cashed. And the people had to be tracked down by the treasurer to say, you know, did you ever get that check? I mean, why haven't you cashed it? I think that he may, you know, basically he mentions it in his affidavit that he was spending time tracking down those people after he had, I think this occurred after he had his conversation with the Secretary of State's office about the wind down process. So I think part of that would be if someone doesn't cash their check and you're successful in tracking them down, but then they still don't cash their check, that changes how much money you actually have in the bank account. It doesn't change what you have on in your checkbook register, right? Until you void that check. So they couldn't determine in the end, they couldn't determine immediately how much money they would have to give to charity until they tracked down the checks that remained unpaid or I'm sorry, unnegotiated.
I had one, but I had it for, I guess, for both. So, Mr. McTighe, in your experience, is it uncommon or common to have overlap from one committee to another?
Well, actually, yeah, I'm glad you brought that up because I've had experiences that I've been racking my brain, okay, over the last 30 years, where we have had at least one and maybe 2 committees that have overlapped as part of the wind down process. I will say this, that those, and I recall actually fairly distinctly the conversation that I had with the head of the campaign finance section, although not under the current Secretary of State, it would have been under Secretary Husted, okay, where we had that situation. And what we were told was, well, as long as the committee, that is winding down is actively working to wind down, okay, I can't remember if they said they're not doing any fundraising, but is that they were actively working to wind down, that there'd be kind of like a grace period, an unspecified grace period, okay? And so that was a distinct conversation I'd remembered having with the prior Secretary of State's campaign finance staff. And I think I have a much more vague recollection of something before that. So when I was told by the treasurer that he had this conversation with the current Secretary of State's office, I said, in my mind, well, that was consistent with conversations that I had had in the past. Okay, and because in part we believe that the Secretary of State has a certain amount of flexibility in deciding on referrals. I raised this in my email correspondence with Mr. Katz, that it says that the Secretary of State, that when reports appear, reports or statements that are required be filed appear to violate the law, that the secretary shall do a referral to the commission. And the question of whether it appears to violate it comes down to kind of an interpretation of, are you, do people have a little grace period or don't have a little grace period? It would quote appear that the current Secretary of State's position right now is that there is no kind of grace period. But again, that I think becomes a change in interpretation that is being applied retroactively here. And is my past experience is why it didn't raise a red flag, if you will.
I'm sorry, you want?
No, I had another for
Yeah,
Mr. Katz.
Okay, go ahead, yeah.
So I may have missed this, and I'm sorry if I did, but I guess I'm wondering, we have a sworn statement from Mr. Durkin. Is there a sworn statement from Moore-Katz as to the conversation that they had?
Thank you for that question, but no, sir, he's provided that affidavit yesterday. And as well as I just know there's not an affidavit from this Moore-Katz.
Yeah, I will, if I can follow up on that. I do want to point out that in the 7-page email chain, I do raise, I think in my very first email with Mr. Katz, that conversation that, now that's not a sworn statement, but we have a sworn statement now from Mr. Durkin.
Perspective, sir, that you're asking for an affidavit that says you can't violate Ohio law. Like from our standpoint, the examiners that have been there 26 years, I think is our longest, 10 years is our newest. They know that you cannot have more than one campaign committee at a time. There is no way whatsoever anyone would tell you you can have more than one Ohio campaign committee at the same time.
And I appreciate that. I was going more to their actual conversation.
Is that,
Yes, and so, sorry.
right, that's clarifying.
And so we would discuss the different options of how to handle things, reminding that the judicial canons are not Ohio law. And so we don't go in to examine whether or not you had overlap between a House committee and a judicial committee. That is not Ohio law that prohibits that. That is a judicial canon that's outside of our purview. And so from our perspective, there are many options for how to go about handling things. If you're worried about potential looking at a single report, you can file 2 reports. You can file a termination report that shows the end of the activity getting down to $0. And then you can file a voluntary report for the next committee showing that you started at $0. Nothing prohibits you from having that clean cutover if that's what your priority is. The only body that might care about the overlap is the Board of Professional Conduct, I believe they're now called. And so
Professional responsibility.
No, I understand that, but were you or were you not, were you part of the conversation with Moore, Kester, and Durkin?
I was not there for that phone conversation.
Thank you.
One or two in 30 years doesn't sound very common if you were asking that.
I'm wondering, I'm wondering, so this was a phone conversation between Mr. Durkin and Ms. Moore-Kester?
Yes, I believe it was.
So there's no documentation on anybody's part that this was his interpretation of the conversation, basically.
No, there's no documentation that, created at that time. I mean, the affidavit is the only documentation documenting a verbal conversation.
Thank you.
The colloquy just has answered my question. Thank you.
I have a couple of questions, Chair. So, and I guess this question was reinforced by the chair's questions on term limits, but I mean, and not familiar with the laws of judicial conduct and whatnot, but I mean, it seems to me, especially if you're term limited, that you wouldn't just sort of, wake up and decide at the year 180 point to run for a judgeship. it kind of goes back to, you know, then you answer Ms. Tavares' question about why it wasn't, I mean, when you first said it sounded really simple to close, now it sounded a little bit less simple, but still, why not much earlier? I mean, it seems like this would have been a decision that would have happened months in advance, not kind of off the cuff.
Well, Mr. Knight, the only response I can really give to that is I think that the treasurer, Mr. Durkin, was relying upon the conversation that he had with Secretary of State's office that a certain amount of overlap would be tolerated or would not be a problem. Perhaps based on that, they didn't move as quickly as they might have. I don't know. I really don't know that I can answer the question other than to speculate as I just did.
And my second question, I mean, I'm not an attorney, so bear with me, but it kind of felt like you provided a laundry list of options that we could choose for there to be no violation, right? And kind of pick whichever one applies, and maybe that's a common, maybe it's not. But, I mean, some of them, to me, felt in opposition. On one hand, you said, or at least I interpreted, that the statute didn't really apply because it didn't fit both purposes. On the other hand, you said things don't apply because it's more convenient administratively for the Secretary of State. I guess my question is, I mean, A, which is it? And B, I mean, as I sit here from, I guess, a layman perspective, yeah, sure, you have 180 days to fundraise as a judgeship. Probably knew that kind of, you know, a ways in advance. And part of the argument is, oh, well, we needed to do this so they could fundraise the full 80 days as opposed to follow the statute, which would have closed it. You could have waited and just had less time to fundraise. So, I mean, I guess that makes it feel like the convenience was more from the Leland side because it fit, you know, their view of fundraising. So I guess it's kind of two questions. One, I mean, is it the convenience or is it the statute? And right, and why not just, you know, the law, follow it, and you've got less time to fundraise?
Mhm.
But I guess there's two kind of questions in that.
Sure. So going back to the beginning of what you were bringing up, lawyers are well known for making arguments in the alternative.
Okay.
You know, my first argument today is that the statute in question requires that or prohibits having more than one committee in existence at the same time for both fundraising and expenditures. And in my mind, that is by itself a sufficient basis for the commission to find no violation under the facts of this case, because fundraising was not going on in both committees at the same time.
Okay.
Then I'll pivot and say, but in the alternative, if you don't accept that argument, then there are a number of other arguments, including the estoppel argument, the retroactivity argument, the administrative convenience argument, which all deal with different kinds of, those are more like defenses, okay, that are brought up when laws are attempted to be enforced against a person, as is the case here. But those laws cannot always be enforced if you have a satisfactory defense. And so that's the argument on those.
Fair enough, thank you.
Okay.
Yes, and my question is how do you respond to the Secretary of State's, I don't know if I would call it an argument, but a statement of fact as to that there could have been a filing of, my words now, bifurcated report where I think report of the committee and then the other ones were informational. I don't know. You heard his argument, how you
Right.
describe it. I'm
Yeah.
probably representing it well.
Yeah.
You know, and
Right.
and I'm going to bring it back to your point. You know, when we started this as a matter of confusion And it seems as though what he proposed is a mechanism maybe that others use, that there would not be confusion. So I just want to hear your response to that.
Right. I think what Mr. Katz said is that an option would be for the committee, the state rep committee, to spend down, go to zero, terminate, and then register a new committee. So that's one of the two options. I think that's the one you're referring to. No?
That's not the one I'm
Oh.
referring to.
Okay. Well,
Yeah,
It was a voluntary report, so not waiting until the end of the reporting period.
Oh, I
but just
see.
Go ahead and file a voluntary report on November 5th, showing all of your activity getting down to $0. That way you can then file
Okay.
a fresh report next time.
well, yeah, but you'd file a termination report, which is, I think, what you're referring to as a voluntary report, right?
so no.
No,
Okay.
you wouldn't have to have terminated. You just get to zero, show that you've gotten to zero on that voluntary filing. And then your next report, whenever it's required, would show that you started from zero as of the date after that last voluntary report.
Okay, thank you. Actually, I'm not aware that you can do that, because first of all, when you file a report, you have to say, is it a pre-election, a post-election, a semi-annual, or an annual? Okay, and it has to cover the period under the law for those reports. So you have to designate this, what kind of report it is. And there's a certain reporting period that goes with that. So I'm not really, I wasn't aware that you could file an interim report, if you will, if that's, I don't know what else to call this, okay? Because you have to file a report that covers the entire period when you designate it as such. But that, I mean, that's all I can say in response to that. As in terms of that being an option.
Okay. Would you like to speak to that?
It's a very common practice for committees to file voluntary reports, whether they're required to be filed or not. Some PACs, for example, file every single report just to make sure they never miss one. The reporting period is then covered by the pre, the post, and the semi, or the pre, the post, and the annual. So there's nothing that stops the committee from filing a voluntary report, because their reporting will be completed at the end with that second report. We can then look at the entire period and see that it has been reported, even though it's been broken up into multiple reports, but they have covered the entire period by that multiple filings.
Well, if I can address just, oops, sorry, real quickly. I mean, it's true, there are PACs that file reports on every single deadline, whether it's required or not. But when they do, it covers the reporting period that they're filing for. So, and you know, but if you're going to allow reports to be filed as interim reports, if you will, before the end of a reporting period, then it seems to me that should be in the Secretary of State's campaign finance regulations, letting people know that they have that option, rather than simply being I guess, a practice that's accepted.
It is in our handbook, which covers that the next report shall cover the activity since your prior report. So if you're choosing to file pre and post primary reports, when you file that semi, you're only reporting the new activity since that last report. So you can call them interim. We tend to call them voluntary reports when they're not required, but so long as you are not duplicating activity, the proper way of reporting is simply the activity since your last report was filed until either the deadline or whenever you voluntarily choose to report. We have pretty much every candidate committee chooses to file their contributions through the date of that report, but then only includes their expenditures through the required date to make their balances look a little nicer. So that is voluntary reporting that they're doing. And then their next report, they just don't cover that activity that's already been reported. So the idea of a voluntary report is a very common activity.
Well, if I can respond just briefly to that, I'm sorry. The handbook, first of all, campaign finance handbook is not a regulation. Okay, it's some guidelines, if you will, from the Secretary of State's office. It doesn't have the force and effect of law. Second, it does say that, that when you file a report, that's, you're required to file, that you pick up from where you left off on the previous report. But it doesn't talk about filing voluntary reports or filing reports. It doesn't talk about any reports other than those that are specifically prescribed by law. So.
Actually, most of my questions were answered in my brief back and forth, so I appreciate it. But the one remaining beyond the, does it cover and is it all encompassing for that official filing deadline? Does it include that voluntary period, which you clarified? The question I would ask is that information beyond the handbook made known to the campaign at that time, that they could do that voluntary report that was mentioned as a means of starting afresh and getting that transition to be in the transition with these?
Yeah, I don't think so. Okay, I don't think that option was discussed. But I'm also not the person in my office who had the conversations. Was my associate, but I don't recall that because, I mean, I would have actually taken some note of that as being an option for the future for a number of candidates who might have raised a lot of money and want to get that out there right away for the media to pick up on. Okay, but as filing an interim report.
Sorry, Mr. Chairman. Did you, anybody in your office aware of any such communication?
So while I was not there for the phone conversation, I can say with certainty the examiner we're talking about is our assigned examiner for the judicial committees. She's very familiar with the judicial committees and advising them and knows all the different variations, and this would not be one of any of those options. It sounds a whole lot more like he kind of pick and chose from the different options to then actually do what he did. But if I may, I need to strongly request you not accept his interpretation of the 35-17-081, that a committee must be both doing contributions and expenditures. Campaign contribution limits are per committee, and if you allow a candidate to create a committee, do fundraising, and then declare that they've stopped raising money and create a second committee and started raising money and then a third committee, I mean, they could create limitless committees who then are just spending money, and that would wholly violate the law that restricts to one Ohio candidate committee at a time. Thank you.
Mr. Chairman, may I have a follow-up question in respect to his interpretation of it not being the law, but a handbook? Is there any expounding that your office might want to do?
So I couldn't quickly look up the statute, but the Secretary of State's office has authority to issue guidance. The campaign finance handbook from the statute is our guidance. So that is the official guidance as provided by our authority under the revised code.
I will point out that that there are campaign finance regulations, quite a few, a lot less than the Federal Election Commission, to be sure, but the Secretary of State does promulgate regulations governing campaign finance and updates them every, I think, 5 years. And there's nothing in the regulations about voluntary reports.
Is there any other questions from commissioners? Going once. Mr. Executive Director, would you like to give me what you've heard here today? Would you like to comment?
I would gladly like to comment. I'll try and be relatively brief too. With all due respect to Mr. McTighe's arguments, and I have great respect for Mr. McTighe and where he comes from. He represents his clients well. Alternatively, I appreciate what the commission did, and it's like you said, an advisory opinion. But if you look at 35-17-081, the very first sentence of that statute states, and I appreciate his interpretation of it as it relates to the use of the term "and," but it says, each candidate shall have no more than one campaign committee for purposes of receiving contributions and making expenditures, period. Talks about one campaign committee. 351710J, which was enacted in 1995, says the same thing, that a candidate shall have only one campaign committee for all of the offices for which they are running. While Mr. McTighe was willing to offer arguments in the alternative, I'm not willing to offer arguments in the alternative. I'm offering that the statute says, these statutes say what they say, and there is only one campaign committee allowed for any candidate. And I appreciate the difficulties that the judicial canons place on candidates when they're either running, when they want to choose back and forth, and what, the statutory provisions don't prohibit someone from, carrying over a campaign committee from one campaign to another, state senate to House of Representative, state senate to county commissioner, whatever the case may be. Judicial canons do it, so that's got to come into play here. And then going through all this, I'm thinking back to a case very early in the commission's time, since it's been an independent agency, which honestly I had forgotten was appealed, and I've circulated a copy of that appeal, the decision to everybody. It was the case of Ralph Kirk for mayor against the Ohio Elections Commission, where he was accused appropriately of having two campaign committees. After the commission found that there was a violation, but similar to my recommendation here, a violation but for good cause, not without a fine, that decision is appealed, and that the decision of the commission was upheld by the Franklin County Court of Common Pleas after the 119 appeal. And if you were to read the various elements, at least the various elements of that decision issued by Judge Schroeder at the time, it certainly, I think, gave respect to some of the Kirk arguments as it relates to what he was going through. He had a situation there where there was an outstanding loan that he kept the committee, his mayoral committee open so that he should pay down that loan. But the court ended up agreeing that the commission's decision was satisfied and was reliable, probative, appropriate. And it gave deference to the commission's decision at that time to find that there was a violation. And so I feel very strongly on all of your behalf, so all due respect to Mr. McTighe's argument, that the statute is very clear. It says that you can only have one campaign committee. And I think a decision other than finding that there's a violation in my opinion, would be inappropriate for this commission to decide, as it's our responsibility to uphold the statutes. I'll be glad to answer any other questions that the commission may have.
Mr. Chairman, I have one of executive director. So, Phil, Mr. McTighe makes the argument of estoppel by entrapment. And if in fact, this is where I'm troubled with this whole thing. So in fact, if Mr. Durkin and Laura Hester had this conversation and she gave him some mitigation, now we don't know because we don't have a sworn statement from her, we have a sworn statement from him, or an affidavit, I should say. But if that was in fact the case, how would you then weigh that?
I believe I have weighed that, and that is one of the reasons why I go to a recommendation of still finding a violation, but for good cause, not imposing a fine. Because to me, the statutory provisions are there. 081 has been there for, I don't know how long, probably 40 or 50 years. 351710J, which prohibits having more than one campaign committee, has been there for 27 years. And so to me, the statutes are very clear and straightforward. And there are times when, a board of elections, in this case, not saying that they did, but the Secretary of State's office may give someone bad information. And there may be reliance on that, but that doesn't change what the statute says, and that doesn't change, somebody could say, oh, it's okay, just file your campaign finance report whenever you get a chance, that's okay. And then they file it 4 days late, and then the board refers them for a late filing, and they say, wait a minute, you told me it was okay, to just go ahead and get something in. Well, I'm aware of those kind of circumstances happening in the past. And that doesn't change the statute that says you have to have your, pre-general date by this, or your post-general date by this, or your annual report date by this. And I don't view this any separately, where the statutes are very clear. A candidate can have one campaign committee, and that's it. And, and so I respect what has been submitted to us. That may have been said. Let's say it was said. It was bad information. He should have known, that doesn't excuse anybody from knowing what the law is and having the law apply to them. But that's where, to me, the difference in terms of what we can do is we can find that there's violation, but there is good cause that the violation occurred, and that's my recommendation.
Here I have a question to the executive director. Phil, are you finding, are you recommending good cause as opposed to a fine because of the, this could be a situation where there was just confusion, right? Or what we refer to in my business, packet errors, right? You hear what you want to hear. So both, sides be telling the truth here, but is the confusion related to the conversation why you're recommending good cause, or is it because it's a first offense or other?
It's a little bit, I'd say it's a little bit of all of those. And certainly I'm taking into consideration, the statement by the treasurer, of what he was told. That's a part of it. As I indicated on my thing, we've got a boatload of priors involving Mr. Leland, but those came from when he was the chairman of the Democratic Party and aren't relevant to what's going on here. So this is a first time violation. I don't recall seeing, I know it was probably listed here. I'm not recalling how long the two committees were open simultaneously, but I don't believe it was that long. He was, getting rid of the remaining funds. It was only about $300 that came into play there. And so all of those factors go into my decision to say, in this set of circumstances, there's good cause not to impose a more restrictive fine or penalty than finding good cause.
Great, thanks. Any other comments by any of the commissioners, any questions? Okay, Mr. Executive Director, just for the sake of the both of the record and just making sure we're clear as to we're prepared to make a motion to rule here. What is the question here at the preliminary review stage? What are we voting on? I just want
We have received a referral from the Office of the Secretary of State, case number 2022-S-001, that asserts that there has been a violation of 3517-081 that again states each candidate shall have no more than one campaign committee for purposes of receiving contribution and making expenditures. Goes on to say other things, but that's the only thing that's really pertinent to what we're talking about here. And so that is what is before us, is whether there's a violation of that statute. I believe there is. And again, my recommendation is to find a violation of that statute, but for good cause, not impose a fine or refer the matter for further prosecution.
Okay, and would it also be true that the choice of the commission would be to one, follow the recommendation, two, make a different ruling, and three, bring it to a full hearing to have people come in, for instance, the people that did these emailings and callings and all that, come in for a full hearing?
That
That'd
is
be the three choices.
Yeah, right, correct. The choices are first, we can find a violation to dismiss. We can find a violation, and if the commission was so inclined, could impose a more serious sanction than I have recommended, either fine or referral, or we could set the matter for hearing, correct?
Okay, all right. Commissioners, hearing those three options, any discussion on the options based on what we've heard here today?
Mr. Chairman, I have a question. It's going to get me in trouble. May I ask the executive director to define numerically float load? You don't have to answer that. I do have a motion. I move to accept the executive director's recommendation as stated there.
Second.
Okay. We have a motion that's been duly seconded. Any further discussion? Okay, hearing none. All in favor, please signify by saying aye.
Aye.
All opposed, same sign. Okay. Motion carries by a vote of 6-1.
Yes, it does. Thank you. Thank you.
Thank you for your time.
It did not be.
Oh, no.
Okay,
I just wonder.
Truckloads sometimes. You come in. Good, because, yeah, I mean, sometimes it's both. Are we out?
Yeah.
I don't know.
It's both.
all right, commissioners, we're going to take a 10-minute break to allow the parties that have been waiting to get themselves together.
Commissioners or?
Us too.
Which one are we going with first?
11:30.
I would think we'll just take it in order, do 19 first.
Okay.
Well,
19 is the big guy.
19 is the curveball, yeah.
Okay.
I mean, you're on both of them.
Right, I just want to make sure.
That also allows Don to leave if he was so inclined after we get the first one done.
That's true.
All right, the back on the record. First case we'll be calling in the session is versus Parabol, case number 2022G-019.
Mr. Chair, members of the commission, the complaint here essentially asserts that the respondent, candidate campaign committee, and state party all improper or failed to properly reflect certain in-kind contributions and thus filed incomplete campaign finance reports. In simple terms, that's it. A response was submitted by Mr. McTighe on behalf of his client, Mr. Purwall, and his campaign committee. You have a complaint. That response was submitted to you. In addition, the Ohio Democratic Party is a party to this complaint as well. Scott Hubey is present on behalf of them. No response was submitted to the commission on behalf of the Ohio Democratic Party, but Mr. Hubey is here and presumably will make a presentation to the commission once the opportunity is afforded him, if the commission wishes to hear from counsel to all parties.
Yeah. Phil, did they also get my response memo?
Yes.
Okay. Mr. Chairman, members of the commission, Kurt Hartman on behalf of the complainant here. Since you do have a copy of my memorandum, in light of the respondent submission, I just kind of summarize that and call to the commission's attention a few additional points that we believe clearly establishes that in-kind contributions were made. And indisputably, those in-kind contributions were neither reported as being made by the Ohio Democratic Party, nor were they reported as being received by the Purwall campaign. If you look at the numbers that we're talking about, based upon the records that were submitted by the Purwall campaign, we're talking in the neighborhood of just over $287,000 and in-kind contributions that went unreported. Yeah. At the outset, no, this is not a question about the legitimacy of this arrangement that existed between the Paraval campaign and the state Democratic Party. We have no issue with that. We believe it is proper under the law. What we believe, though, must be done is those expenditures by which employees of the state Democratic Party are selected by the Paraval campaign, but are provided exclusively to that campaign by the state party, and the campaign committee can hire and fire them at their will, constitute in-kind contributions that must be reported. It's in this interest of full disclosure. I would call to the commission's attention. I outline in the memo the definition of in-kind contribution that is adopted by the General Assembly. Anything of value other than money that is used to influence the results of an election or is transferred to or used in support or opposition to a candidate or campaign committee, and that is made with the consent of, in coordination, cooperation, or consultation with, or at the request or suggestion of the benefited candidate or committee. The other definition, which I did not cite in my memo, but I will call to your attention, is actually the definition of contribution in 3517.01C5, where contribution by the General Assembly is defined to mean a loan, gift, deposit, forgiveness of indebtedness, donation, advance payment, or transfer of funds or anything of value, including, and it goes on, including the payment by any person other than the person to whom the services are rendered for the personal services of another person, which contribution is made, received, or used for the purpose of influencing election. So go back, the payment by any person, payment by the Ohio Democratic Party, other than the person to whom the services are rendered. Services are being rendered to the Paraval campaign and to AFTAB Paraval. And so the concept of a contribution clearly recognizes and encapsulates the situation. They tried I think the key thing, and again, I kind of do the bullet points at bottom of page 2, top of page 3 in my memorandum, that really shows this, I don't know if it's symbiotic relationship or this it's more than a coordination. It is a collusive effort. Nothing wrong with it illegally. It's just got to be reported. The campaign chooses and identifies certain individuals to work. Those individuals are actually employed by the state party. But those employment is done, quote, at the request of the campaign committee, quote unquote, for the benefit of the campaign committee, and quote unquote, to be providing services exclusively to the campaign committee. And so when you look at it, we simply believe that they need to address and report those contributions, that $287,000+, and it goes to full disclosure to the public. And that's the whole gist of campaign finance laws. I know the executive director is recommending a violation with no fine. I believe, obviously, I agree with the recommendation of finding the violation, but I think we really need to pause in terms of saying, is this really a case where there should be no fine? We're not talking a $25 tray of cookies that somebody provided in-kind contributions are. The magnitude of these in-kind contributions is significant, and it all went unreported. You look at the timing since these reports, all these were covered by the post-primary, pre-general, and post-general 2021 election. And respectively, it's been 510 days, 378 days, and 328 days since those reports were due. If you go $100 a day fine, which is the maximum, you're looking at a total of 1,216 days for $121,600. I'm not suggesting we go that boatload of a figure, but I think there needs to be some hammer, if you will, behind it. The other thing I think you also need to look at in terms of the remedy is we still have inaccurate reports out there. My suggestion would be that the commission impose a significant fine, but if amended reports are filed that accurately reflect these $287,000+, that a certain portion of that is abated. that gets the reports corrected where they should be publicly, and gives that incentive. The final thing I would point out in terms of, and I'm sure the Democratic Party's been before the commission off and on various things, but this isn't Mr. Purval's first dealing with the commission either. He was found in violation in case 2018 G022, case dealing with using state campaign committee funds for a federal office run that he sought and was unsuccessful on. So he's been involved in this. He's been in public office since 2016. It's not a novice coming into the political realm. So again, the foundational issue is simply, it's not the legality of the arrangement, it's whether they have to be reported as in-kind contributions. You look at the statutory definitions, they meet that definition, should have been reported, they failed to report it. Thank you, Mr. Chairman.
Yes, Lou.
Good morning, I'm Don McTighe. On behalf of the respondents, AFTAB Pureval, Friends of AFTAB Pureval, and Evan Nolan, the campaign treasurer. So I think Mr. Hartman has laid out pretty clearly that, what's not at issue here is the arrangement where ODP provides staff to work on the campaigns of various people, not just Mr. or Mayor Pureval. That the issue is whether or not it's an in-kind contribution. So it's clearly not so much a factual issue. It's not a factual issue at all, really, here. It is an issue. What's at issue here is the interpretation of the law regarding an in-kind contribution. So Mr. Hartman correctly quoted the statute on the definition of contribution and definition of an in-kind contribution. And let me say that it is the law and the regulations and interpretations that define whether something is an in-kind contribution. Saying it over and over and over doesn't make it true, doesn't make it an in-kind. You have to look at what the law is, what the regulations are, and what the interpretations are regarding what is a reportable in-kind contribution or a contribution or in-kind contribution. So what he fails to point out is the Secretary of State's regulation defining in-kind contribution, which is Ohio Administrative Code Section 111:2-5, paragraph A, defines in-kind contribution as follows. It includes the provision of goods or services without charge or at a charge which is less than the usual and normal charge for such goods and services. What we have in this case is services were provided, staff support were provided by ODP to the campaign, as it does for other campaigns, but it was not provided without charge. And so I want to go through some of the evidence that demonstrates, we submitted what I consider to be an extreme amount of documentation. I'm going to point to several of the affidavits. First of all, we have the affidavit of the treasurer, who basically said in paragraph 2 of first page says that all costs related to the staff persons named in the complaint, including wages paid, all federal, state, and local taxes, workers' comp, and ODP's service fees were billed. And ODP billed these to the campaign. The payroll is bi-monthly, so twice a month. So you have January 1st to January 15th. Then I think there's a two-week lag when the paycheck is cut. During that 2 weeks, ODP sends essentially an invoice to the campaign. This is what you owe for the upcoming payroll. Okay? So we have the affidavit, not only of the treasurer, but we included the affidavit in our response of Sarah Ross, who is the HR director for the Ohio Democratic Party, in which she says in her affidavit that in each case, ODP invoiced the committee prior to the scheduled payday, and the committee provided the funds to ODP prior to processing payroll to fully cover the payroll and associated employers' taxes, a payroll service fee. I'm sorry, yeah, it says and a payroll service fee. Okay, it goes on to say that attached to her affidavit is the breakdown for every single payroll. So if you look at that, for every payroll, an invoice was sent ahead of time, and it breaks down in the documents the name of each employee, and then the next column is their salary that's going to be paid that pay period. Then it has the employer tax, so that's essentially your FICA. Okay, benefits if they're getting any, because some of the employees get healthcare insurance through ODP provider. Then it has administrative fees. Okay. Then it has a workers' comp fee, and then it has the total for each employee. So just picking the very first one here, Alexandra Waters. Her first check was $3,750. The employer tax $609.38. Administrative fee $93.75. So that's just for her, $93.75 for this one check to her, okay, is being charged to the campaign. Included in that is that $5 that's referred to as a payroll fee. And I'll come back to that in a second. And then the workers' comp charge. We have the affidavit of Alexandra Waters, which basically says the same thing. Okay. We also have the agreement. It's called a payroll service agreement. It's attached to two affidavits in here. The one that the Pure campaign executed with ODP. And it starts in the second paragraph by saying ODP utilizes a payroll processing firm. Fine. Okay. And which pays employees through direct deposit, remits the necessary payroll taxes, both employee and employer, to the Internal Revenue Service, State of Ohio, Bureau of Workers' Comp, Ohio Unemployment, and so on. And then on the second page, it has a paragraph that says, by the 5th of each month, ODP shall send an invoice to the committee via email that itemizes the charges for salaries, employer liability taxes, benefits, payroll processing fees, and in parentheses, $5 per employee per pay. That's the payroll processing fee. Essentially, I think that's the fee that they're paying to the payroll service, because on top of that, they have their administrative fees, which it goes on to say that the invoice also includes the simple IRA match, if there is one, and administrative charges incurred. So this is under the law, not an in-kind. If someone is paid to work on your campaign, but you are paying for that service, whether it's to the Ohio Democratic Party or to your consultant or to your media buyer or to your pollster who's paying employees on their staff that are working on your campaign, yes, they are being paid by someone to work on your campaign, but your campaign is paying in full the cost of that. Okay, so if it was paid for, it's not in kind. If it's not paid for, It is in kind. It's really is a simple question here. And you know, it would be nice if the statutory definition incorporated what the Secretary of State has in his regulation on this. But it didn't, but he has it in the regulation, which has the force and effect of law. And the Secretary of State, I'm going to guess here, but I think it's a pretty educated guess, that the Secretary of State in adopting that regulation followed the Federal Election Commission's regulation on the same subject, which is found at section 100.52, where they define in kind, or they define the term anything of value for purposes of in-kind contributions as the provision of any goods or services without charge or at a reduced rate. The same thing the Secretary of State has in his regulation. So, you know, if, you know, it's not in kind because you paid for it, and we paid for it in advance even before the payrolls went through, when we paid all of the administrative fees associated with that. It's been fully documented here. And again, this isn't about whether it's a political party. It has nothing to do with it being ODP. We could go out and hire one of the temp agencies, okay, to have campaign people work on the campaign. That's, in my mind, that's essentially what ODP is doing. They're essentially representing providing almost like a temp agency type thing, because these are employees of ODP, legally speaking, okay? But if we were to go out and hire a temp agency to do the exact same thing, that temp agency would be billing us and including their administrative fees, and we would be paying that temp agency. So would we have to report an in-kind contribution from the temp agency? No, obviously not. Okay. The word exclusive has come up a couple times, both in what Mr. Hartman has filed, although he never really explains what the importance of that is. I don't see how it makes any difference whether the person who is being paid by ODP is working exclusively on a campaign or working on multiple campaigns. The fundamental issue is whether or not it's an in-kind contribution. So the other thing I would point out is that it doesn't matter, this $287,000 that he brings up, again, is irrelevant. Whether it was $100 or $287,000, it's either in kind or it's not in kind. Okay, it's a straightforward question of law. And I would respectfully request that the commission find no violation here. All of the evidence establishes that all the fees connected to these employees, salary and everything else, including the administrative fees, were paid by the campaign. That cannot be an in-kind contribution. Or if it is, we're really turning the head on its law, or turns the law on its head. Either way. And, you know, we're going to have to apply that across the board to other situations as well. Thank you. Try to answer any questions you have.
Question?
Yes, I do have one question. So I'm trying to get the difference between the two statements. So one is saying X amount of money was given in kind. The other is saying there's been a compensation appropriately. Are these people working at the normal rate that they would normally be compensated for the services they're providing? Campaigns are very expensive. So I'm just curious about the rate at which they were contracted. Is it less or more than they're normally contracted for the normal position within the ODP, or other contracted services they provided in other places?
Hey, Don, do you want
Other
me to answer that?
candidates?
You know,
Yeah, I think,
Let me ask
Sorry.
a question to that.
Okay.
Related. What is the reason that the invoice and payment is in advance as opposed to arrears?
For one thing, because I think ODP is smart and they're not going to pay all the employees working on your campaign and trust that you're going to send them the money. Okay, that's the cynical response. The legal response too would be we want to avoid an extension of credit. Okay, so if the money is paid in advance. Now, with regard to the other question, I think Mr. Hubei wanted to try to answer that about, I think it was your Ms. Hagan's question.
Yeah, so Scott Hubei on behalf of the Ohio Democratic Party, and I'll be getting up to say a few things after Don is done. But to your specific question, Commissioner Hagan, the employees are paid at a fair market rate, and the way that the service agreement begins is the campaign will tell ODP, here are the campaigns we want to have be paid through the payroll program with you as the payroll provider. This is how much they're supposed to be paid. They send us the funds in advance, which is what you just asked about. And then twice a month, they get their payroll. And they essentially, it is no different than, you know, like a payroll provider like ADP or Paychex or, you know, one of those where an employer pays a payroll provider and then the payroll provider issues the payroll. ODP is operating in functionally that capacity for the campaigns.
Mr. Chairman,
If I could I add something to that though, on behalf of the campaign? I mean, I think the campaigns, and because it's not just this campaign where I've served as legal counsel to and dealt with payroll and through ODP. Campaigns choose this service. They don't have to because it makes life simpler. Okay, they have somebody else doing all the payroll, the tax withholding, things like that. Could they do like Paycor? Yes, or you know, but the problem is there that those are payroll services. Okay, in terms of ODP, there are some added benefits because they're employees of ODP, that employees have the option of healthcare coverage if they want it. They have the option of getting a simple IRA if they want it. If they do choose those expenses are then billed back to the campaign. So there is a convenience factor. It's not because it's going to cost them less to use ODP versus just having them on being paid directly by the campaign. Sorry.
Mr. Chairman, I'm still trying to arrive at the differential between the two assertions. One is saying fair market value, the other is saying a more substantial amount. And I don't know where that differential breaks down, but maybe the two parties could speak to that.
May I add on to that as well? So you're asserting that ODP is loaning them. Like yes, Mr. Hartman.
Okay.
So you're asserting that ODP is loaning them out as opposed to them being paid, like, you know, I guess I'm trying to, I think we're trying to arrive at the same.
I think, and there's a few other points I think which are critical, but you know, the arrangement, you know, this is not a arm's length transaction where you're buying services off the open market. This is a close, collusive arrangement. Nothing wrong with it. It's a question of having to be reported. These employees, and you know, it's interesting. One of the things was, you know, Mr. McTighe said, "Oh, this is just like a temp agency. You go out and hire them." Who tells the temp agency, "I want you to hire this person, this person, this person"? That's not the way it works. Who says this is the salary for the person that you're going to hire as an employee? It's the campaign that determines who gets hired. It's the campaign that determines how much they're going to get paid. And all that is done not by the campaign. All that is determined is paid for by the state party. That makes it totally distinguishable from ADP, Paychex, even a temp agency. This is that close collusiveness. And so what happens is, yeah, these guys, the campaign says, we want you to hire these people. We want you to pay these people. The state party says, okay, we'll hire them. We'll put them on our payroll. We're going to charge you for it. But it's interesting when the Parvell campaign transferred money to the state party reported it as a campaign contribution from the campaign committee. That's not buying services. That's the campaign. And that happens all the time. Involved in campaigns in terms of mailers, right? Sometimes, okay, the state party, they get the bulk rate much cheaper than, so local candidates would now say, hey, I need the state party to put out this mailer for me. So the local campaign committee writes a check to the state party, contributes to the state party. The state party then puts out the mailer paid for by Ohio Republican Party, Ohio Democrat Party. No problem with it. All that is reported. That's reported as an in-kind contribution. This is really no different. This is, the mailer has paid for by Ohio Democratic Party. This is really no different than if these employees have stamped on their head, if you will, paid for by the Ohio Democratic Party. And so I think that distinction, so you look, they reported it as contributions to the state party. That's how the state party viewed the receipts from the Powerball campaign. They didn't report it as other income. They didn't report it just, hey, this is a contract that we're working under. This admin code that he cites, it simply says it includes, it's not a strict definition. If you go to the infamous campaign finance book on page 18 of the chapter 2 dealing with campaign committees, in there, the Secretary of State, under his authority to issue rules pursuant to 3517.23, indicates that, quote, an in-kind contribution is a non-monetary contribution of goods or services that is made with the consent of, in coordination or cooperation with, or at the request or suggestion of the benefited campaign agent of the candidate or the committee. This kind of happened, I think, both in coordination, cooperation, at the request, suggestion, et cetera. So I think the distinguishing it, and again, we go back to the statutory definitions, and that's not the end of the day. It's the General Assembly that determines what the law is. And when you look at that contribution, the definition of contribution under 3517C5, where they specifically indicate that a contribution includes the payment by any person other than the person to whom the services are rendered for the personal services of another person. That's exactly what's happening here. The payment of by any person other than the person to whom the services are rendered for the personal services of another person. That is a contribution by definition as adopted by the General Assembly. Because it's done in a non-monetary form, it's an in-kind contribution, should have been reported. So I don't know if I kind of answered your question with that, but I think I got all my points.
Are you familiar with PEOs?
Enlighten me a little bit if you.
Professional employee organizations, they do the exact thing that you described. The company says who they want to hire. They say what they want them to do. They want the salary to be, and they pay an upcharge.
Okay.
They are entirely designed to do exactly what you say.
And the W-2s issued by the PEO.
Yes, and it's just meant to have, because certain companies, for other reasons, want to pay for a service and not have employees on their books.
Okay.
So.
I understand that. I think, legitimate there, but in this case, we've got campaign finance. This is dealing with campaign finance laws and the definitions of contributions, in-kind contributions, both in terms of the receiving committee or the benefited campaign committee and the state party providing that in-kind contribution. Just simply has to be reported. We don't have a problem with the arrangement. It's a question of reporting it. And I think in this case,
It's a question of the definition of in-kind as well, right? And I mean.
well, yeah, but it's.
And the interpretation that you're having is absolutely, positively, entirely strict to every word. I mean, the view of in-kind contributions in pretty much every context I've ever had is, right, another party pays for it, but they are. The actual payment in this case is coming from ODP. They're paying for the people.
Okay, so
it's not in kind if you're getting reimbursed.
Well, so the same thing when a campaign committee sends a contribution to the state party to put out a mailer. Now, those have always been reported as in-kind contributions. This is no different. Take the mailer, put the person in the place. It's the same. If I'm, you got a look on your face. I'm not sure I make.
So, I mean, and again, I can't speak to this, that's the case, but what I'm hearing you're describing is that the campaign is paying for the mailer that's being sent out.
But they contribute to the state party. They make a contribution to the state party, which in this case, the Puraval campaign made a contribution to the state party.
Okay.
They didn't pay for services. They made a
But the
contribution.
state party sent the mailer.
Yeah.
That is, in my opinion, different than saying we are going to basically outsource employees that we're going to reimburse for. That's a direct reimbursement as opposed to we make a contribution and then something happens and other things.
I'm reimbursing you for I'm reimbursing the state party for the mailer. It's really no different. One is a piece of mail, the other is a person, but they both are paid for by the state party, even though the campaign paid money to the state party to cover the cost.
It depends on the intent and I mean, somewhat semantics. If the contribution is made with the exact intent to pay for the mailers, I would agree with you. If the contribution is just made as a contribution, then mailers go out, then I would not. Here, I'm hearing that the whole point was to pay or send employees.
Okay, if I heard you correct, you said that if the intent was to do the contribution to pay for the mailer, then it would not be, because that's
Then it
never, that
Then it would be.
would be an in-kind.
Yeah.
And that's,
No, no. I'm getting straight for it now.
you've confused me completely, but that's okay. No, I think it is the same. Though, like I said, the mailer stuff is, I've been involved in campaigns 20, 30 years now. Don't remind myself, but I think those have always been reported as in-kind contributions. You report the contribution to the party and the state party reports the in-kind contribution back to the campaign. Nothing wrong with it. It's a simple question of reporting it.
Okay. I would like to actually move some things along here in
Thank
the proceedings. Mr. Ruiz, I've had the opportunity to address the commission. And then as Mr. Ruiz, like to, unless there is some different type of question based on what they feel, I'd like to move to the from the executive director.
Great. And I'll be quick. So Scott Hubey on behalf of the Ohio Democratic Party. Hello again. In short, much of what the Puraval campaign said in its response, which ODP worked with the Puraval campaign on responding to through our Human Resources Director, Sarah Ross. I agree with one point that I do want to make that I think really sums this up, and Commissioner Knight, you nailed it, which is that ODP provides a service to these campaigns, and it is a PEO model, and it has been that going back years. It does this in its normal course of business. What ODP is providing, it receives a full market value, which was what your question was. How much is ODP getting paid and how much are the employees getting paid out? Because if there was a difference in the value as far as the fair market value of what ODP receives and then pays out, that difference would be an in-kind contribution, but there is no difference. And to your question, Commissioner Beatty, and I think this might have been what you were alluding to, is, why does ODP take the funds before, or how does that relate to when people are paid? ODP needs the money from the campaigns to pay for the fair market value of what it is providing. It needs the money first so it can have the money to pay the vendors, whether it's the health insurance or make sure that the taxes are withheld or what have you, to make sure that the employees for these campaigns are then paid what they're supposed to be paid. Another thing I'd like to note is Mr. Hartman doesn't contest the validity of the ODP payroll program resources that it provides to campaigns. I agree. I don't contest it either. One thing that I would contest, though, and this is a little bit of a minute point, but in the PEO model that you were talking about, which is what this is, if you contract with a PEO, if you're a small business or something, the PEO is not going to have control over hiring or firing your employees that you run through the PEO. And ODP in this instance is no different. If ODP had a problem with an employee that worked for, one of these campaigns, we would probably tell the campaign, you can't participate in the payroll program anymore. But the way that we view it in practice is we don't have control over hiring and firing of these employees. We are paid to do a service, and we provide a service, and we provide it for a fair market value. So when the campaigns pay money to ODP, they get the service back. And to Don's point, when he was talking about, the implications that this could have outside this realm, when you pay a pollster for a poll, you pay them the money and they provide the service back with the value of the poll. And if that was viewed to be an in-kind contribution, I don't know how campaigns or state parties on either side of the aisle would pay for anything in the state of Ohio. And I think that really belies the point, which is that there is no contribution here. They're paying a fair market value for what they're getting, and that's essentially what's happening here. So with that being said, we respectfully request that the commission dismiss the complaint because there's no contribution. And because there's no contribution, there's no in-kind contribution reporting requirement.
Okay.
Mr. Chair, can I make one point in response to what was said by Mr. Hartman?
Very quickly.
Okay, yeah. And I think it actually goes back to maybe Ms. Hagan's question, okay? On setting salaries. Mr. Hartman points out that, he says, well, this is a collusive relationship between the campaign committee and ODP. Yes, right, it's all coordinated there. But the arm's length part of the transaction is between the employee, okay, who gets hired. They don't have to accept a job. There's negotiation about what they're going to be paid. You're offered something, they say no, maybe you come back. That's where the arm's length is right there. Thank you.
Okay.
Well, commission members have questions. I'd prefer them to go first. And then I do have a couple of questions for Mr. Dubé.
Okay.
Mr. Chairman, Mayor.
Oh, go ahead.
So the question I have is in regards to, okay, so it was mentioned about a pollster. If a poll was conducted by the party and then on behalf of a candidate would then pay for the poll essentially for services rendered. At least that was a statement that was just made or along those lines. Apologize for not completely encompassing it word for word. My question is, if there was a invoice that was received by a campaign committee of a candidate, why was that not then paid as a service rendered rather than a campaign contribution?
Actually, if you look at the reports that we filed as an exhibit, we report every single one of these payments to ODP on the statement of expenditures as payroll expense or payroll processing. We never call it a contribution to ODP.
Okay. But if I may clarify on that though, and it's not in the record, but the Ohio Democratic Party reported it as a contribution received, not as other income. They reported it as a contribution on all of their campaign finance reports. So I think that's the key thing, how the Democratic Party views that money coming in from the Parval campaign is as a contribution, not other income.
So I just asked why the differential.
Oh, I can answer that. If ODP's reporting said that the money that was coming in from the Parval campaign was categorized as a contribution and not other income, then it was a reporting error, and it's something that the ODP, that we need to amend our reports to reflect that. But ODP was being paid for a service that it provided. And if there was a reporting error, I apologize for that, and that's something that we can absolutely do to amend our reports, but it doesn't change the fundamental nature of the services that are being provided here and why the money is coming to ODP and what ODP is paying for.
Any other questions before we go to the executive director's questions?
So do we know, for certain that that's how it's reported as a contribution?
I'd represent, as an officer of the court, as officer of the commission, you can actually take judicial notice of the campaign finance reports as well. If you search under contributions to the political party, Friends of AFTAP, Parval, they all come up there.
Thank you.
I did.
And I respect what you're saying, and you as well. I just was trying to get it all.
Yeah.
In my mind.
Okay, that answered one of my questions, by the way, was, is that the way they were listed and why? So thank you very much for that. Included in the, as you look at the expenditures that are listed in there, are all of the Democratic Party's costs covered in the amount of payment that is made by the respective candidates to the party? So there's no differentiation between the amount that, that is billed in payment to the individuals, to the salary, and the amount that's billed to I'm not saying that very well, but the amount that's billed to the campaign committee. So all costs of the committee or the Democratic Party are covered in that?
Yes.
Okay. Because I did notice in there that they're listed as a cost or something like that is listed out in there. What does it call it? Administrative fees?
Yeah, if anything, the campaigns might pay, or do pay slightly more basically to help cover the costs of what ODP has to pay for the program. Because our view is if there wasn't an administrative fee, that there potentially maybe could be an in-kind contribution there because you are paying ODP to perform the service. In this instance, ODP does provide a service. And in order for us to be able to run this payroll program, which just for a little bit of background for the commission is one of the things that the state party is most proud of. And it's because it provides a great resource to campaigns that otherwise wouldn't be able to know how to provide health insurance to their young staffers and to just generally make the life on the campaign trail a little bit more palatable when it already is a very hard life. That we do charge an administrative fee so that we can actually provide that service, because otherwise it would be difficult for us to do it. And there's the potential that we could, even though I'm not sure that we would, because it's too generalized as far as the way that the services are being provided to many campaigns, that there would potentially be an in-kind contribution, but because there is a service fee, that would cover even that instance of a potential in-kind contribution issue.
Yeah, and that's what I was going to get into is, so essentially the ODP, it's a net zero circumstance with the ODP between what is paid by the campaign committee to them, and it covers everything related to salary, administrative costs, and everything else. So there's nothing that in this circumstance and in this relationship, there's nothing that the ODP is giving back to the candidates per se.
Exactly.
Okay.
Mr. Victor, if I'm just a point, I'm not sure that's true. Just with, if you look at the administrative fees that are charged on the spreadsheet, why is one employee being charged $93 for an administrative fee and another employee is being charged $16 for an administrative fee, or the campaign's being charged? There's administrative fees. If it's really a zero-sum game for the party, it should be an equal, whether one makes $100,000 or $1,000, the processing that needs to be done is really one and the same. And this disparity doesn't clearly indicate a consistency on administrative fees.
That's a reasonable statement.
Yeah, well, it's a percentage, and part of the reason why it's a percentage is ODP is incurring liability in doing the payroll providing services for these campaigns. So if you pay somebody more, if something goes wrong with sorry, I'll move up here. I should be standing up actually. That when the state party pays more for an employee, and if something went wrong with the tax reporting, ODP would be, on the hook for making that mistake. So therefore, that's the reason why the processing fee and the service fee is higher for employees that are paid more rather than paid less.
Yeah, we can see that pretty well across the board. So if a campaign committee were to complain about the nature of the administrative fee and indicate that they thought it was too much, that's nothing that any particular campaign committee could do with that?
I would tell them they could go to ADP or Paychex or a PEO provider and have somebody else provide the services. We are happy to provide the services for the fee that we charge them. And we think the services and the health insurance that we provide our campaigns is as good as anybody's going to get.
And I'm not doubting your position.
Yeah.
Well, I was given certain other information that I thought I'd go ahead and take.
Yeah.
I want to go into the situation. Mr. Hartman's made multiple references to mailers and how they are handled, how they are handled is the way he phrased it, or the way I'll phrase it. And I am aware that state parties, whether it's the ODP, the RP, in that regard, it's really irrelevant, will do things for candidates. And it was always my understanding that, let's say since we're talking about it, the ODP did television commercials for, Joe Smith, the state rep candidate, and he really couldn't pay for them, so the ODP paid for them. That's obviously an in-kind that the ODP is making to that candidate when they run those commercials. As it relates to the mailers here that he's made reference to, does the ODP always reflect those as in-kinds, even if they're getting money back from the candidate to, to ostensibly pay for that mailer that goes out?
So the first thing I want to say is I'm not sure what the relevance is of mail that ODP sends on, or, to help support campaigns across the state of Ohio at the state, local, and federal levels. But there are some very key differences as far as how mail works at the state party and within state parties, whether it be the Ohio Democratic Party or I'm sure the Ohio Republican Party, and what is happening here. But beyond that, if to answer your question, we do issue in-kind letters for mail, but mail is a fundamentally different system than what this is. And I don't, it's not really relevant to the complaint that was filed here. If it came to, if there was a complaint that was about the mail program, I'd talk plenty about the mail program, but it just doesn't seem to be relevant here because what this is a paying for a service and receiving a service relationship. That is not the way that the ODP nonprofit mail permit works. And it can't work that way under the United States Postal Service regulations. So that's the reason why it's fundamentally different. And that's also not the way that it works, is ODP does not receive money and then say, we will send out this mailer because we've received this money. ODP has full discretion and control over the mail that it sends for on behalf of, or put more clearly, to benefit campaigns in the state of Ohio. So it's fundamentally different.
I don't want to speak for Mr. Hartman, but I think the parallel he's trying to make is, service rendered, payment made as it relates to the situation here, mailing, service rendered, payment made by the campaign committee. And, and if a payment is made from a campaign committee to the ODP for a mailing, and it's an equivalent amount, it costs $5,000 to send the mailing out for Joe Smith, county commissioner, and Joe Smith campaign committee pays $5,000 for that mailer. Is it still reflected as an in-kind contribution to Joe Smith? And if so, why?
But the difference is and again, I want to reiterate that this complaint is not about the mail program, but the difference is it is an arm's length. This is an arm's length transaction when we're talking about the payroll program. The mail program is not an arm's length transaction. Nothing that ODP sends out under it's paid for by the Ohio Democratic Party is sent out without several layers of approval, including mine. And campaigns don't have control over what ODP sends out. ODP has full control over what it sends. So that's what makes, and that's why in that instance, there's an in-kind contribution tied to, at least at the state and which is relevant, the state and local levels, which is relevant to the Elections Commission. The Federal Elections Commission is slightly different and not relevant here. But that's why there's an in-kind letter attached to those.
Okay. Thank you. I appreciate that. That's all I have.
I may just comment on that. He just said it's not an arm's length transaction. I think in the mail and this case, they're both not arm's length transaction. That is the relationship between the campaign committee and the state party. And in that sense, and that's Director, you're right. I was trying to say, paid for services, received the services. That's kind of, but it's the mail thing. And in this case, both are not arm's length transactions. And that's the distinction.
Mr. Richter, if I could add one brief comment about this, it's whatever, someone used the word parallel, whatever parallels people want to draw or not draw between the case in front of you and a mail program and how ODP reports that stuff does not answer the question of whether or not this is required to be reported as in kind. However, ODP is reporting on its reports, mail, it's the mail. And maybe it's right, maybe it's wrong. We have to, in the present case, go back to the statute, though, and say, is this in kind, reportable in kind under the statute?
Thanks. And I was one of the.
And I agree with that question.
Commissioners? Commissioners?
Good recommendations, exactly. Yeah, as Mr. Hartman highlighted earlier, and as you look at my recommendation sheet, it was to find a violation in both instances, but for good cause, none of those were fined. A big part of that recommendation was, I guess I'd say, my misunderstanding, and it was cleared up here in questioning, that my assumption was that the only amount that was getting paid to the MVP by the campaign committee was for wages earned by the individual. And that there was, an administrative fee that wasn't being covered. They've now covered it, they've now clarified that that is the case, and that this is essentially zero net to the party. And so based on everything I've heard today, but primarily including that, my recommendation is going to be to find no violation. I'll be glad to answer any other questions that the commission may have.
Good question. Knowing that they're listed as a contribution, does that play into that at all? As opposed, from the campaign into the ODP?
I was focusing on the issues that we have before us as it relates to the, potentially improper listing of an in-kind contribution. And I'm presuming, we all know what it is, or assuming, we all know what that gets out of you. But I am at least assuming, I think reasonably, that the Ohio Democratic Party has not received any kind of an addendum request from the Secretary of State's office indicating that they have seen some sort of a problem or error in their campaign finance report that would then subsequently be created. Therefore, they would be within any kind of 21-day window to make whatever changes that they need to make to amend their campaign finance reports to properly reflect that. And so I would hold off making a violation finding on that particular issue because that's not what we're dealing with here. But also because they have an opportunity to amend those reports, or give them an opportunity to amend those reports.
Thank you.
Mr. Chairman.
I was going to.
Oh, I'm sorry.
No, I didn't have a question. I was probably gonna do what she was gonna do.
Oh, go right ahead.
Yeah, I was just gonna move the revised recommendation by the executive director, no violation in the current case.
Second.
Okay, there's been a motion that has been duly seconded. Is there any further discussion or questions for clarification?
Mr. Chairman, I ask a question of the executive director. Would it make sense to continue the case until that campaign finance report is updated so that all members of the campaign or of the commission would have heartburn potentially?
I think we could, but I just feel like the issue that we primarily dealt with today is the failure to include these as in-kind contributions. Were there not to be an amendment filed in a reasonable period of time, that's something that the commission could address down the road if another complaint was filed with us. I mean, but otherwise, I certainly understand.
When you say, I get that, but when you say amend to what?
Campaign finance
To
report.
accurately reflect the campaign
Right.
finances.
Hold on, wait a minute, but what would they be amending? Would they be amending this to be an in-kind contribution?
No, it would be
Yeah,
amending it
amending it
to
as a
list as
service
Other income.
Something other than a contribution as it appears it was listed on their campaign finance report.
Okay, I just wanted to clarify. I understand. Any further discussion or questions on the motion? All right, there's been a motion that's been duly seconded. All in favor, please indicate by saying aye.
Aye.
All opposed?
Aye.
Okay, Council Wolfson.
That would be 5-2 unless I misheard with Ms. Hagan and Ms. Kaufman, Vice Chair Kaufman voting no.
Motion carries by 5.
Correct.
I relinquish my seat.
He's liberated.
Podium.
That was great information, though. Thank you for that.
Yeah, sure.
Very enlightening. Thank you. Am I allowed to say that?
Can't take it back now.
We're able to suss out there.
When in doubt, stay boat load.
Yeah. Nice.
All right, the next case will be the case of Hartman versus Rosowski et al. Case number 2022-B-021.
Mr. Chair, members of the commission, the complaint here asserts that the individual respondent, Ms. Rakowski, was credited with making certain substantial contributions. Was believed that she did not have sufficient monetary resources to properly make those contributions. We did receive a response from Ms. Rakowski that was circulated along with the response, or with the complaint. In addition, the Ohio Democratic Party submitted a response that was also circulated to all of you for your consideration. Mr. Hartman is again here on behalf of the complainant, and Mr. Zubek again is here on behalf of the Ohio Democratic Party. The individual respondent, Mr. Rakowski, did submit a response. I have not had any other contact from her aside from the submission of that response and an original request to have the complaint sent to her, which I did. So she's not represented here today, but she is aware of the complaint and again has submitted a response. If the commission would like to hear further, two of the parties present.
Mr. Chairman, thank you. Members of the commission, Kurt Hartman. On behalf of the complaint, this case deals with, yes, a substantial contributions totaling $444,000 in a 33-day period that was made by Ms. Rakowski to the Ohio Democratic Party. That is based upon the campaign finance reports that were filed under penalty of election falsification by the Ohio Democratic Party. The filings are there. If you look at Ms. Rakowski's response, she acknowledges that that's not her money. She actually says, I have never seen, heard of, or fathomed money in the amount mentioned in the complaint. So clearly we have an issue here as to whose money is it? Why is Ms. Rakowski being reported by the Ohio Democratic Party as the most significant contributor during the 2021-22 election cycle, at least as of the time of the complaint? And they simply say, we got electronic transfers, wire transfers of money. And that's all we knew. We had no idea it wasn't her money. It was some other money. Well, a couple things. One, there's been no amended complaint filed since the complaint was filed several months ago. But simply to function and operate where you get $444,000 in wire transfers and you just blindly accept. I'm sorry, I've been involved, like I said, in campaigns for 30 years. And I'd be dumbfounded of any candidate, campaign committee, or political party that when you find a contributor giving you $444,000, that doesn't raise a red flag, a positive red flag. Because I'll be honest, if I'm a candidate and somebody's contributing that amount of money, I'm on the phone to them, thanking them, and trying to get more money. Yet the Democrat Party says, we just did this, we did nothing more. Based on the best evidence we had at the time, we reported it as coming from her. Well, how did they get her address? That's another issue. They reported a false address. That wasn't her address. Ms. Rakowski, even in her memo, says from August 2015 to May 2019, I was a student at Xavier, and I resided at 1625 Musketeer Drive and 1429 Dana Avenue. The ODP reported the Musketeer Drive, 1625 Musketeer Drive as her address in 2021. And I will represent to the commission. I checked the voter registration files in Hamilton County. She was registered to vote at 1625 Musketeer Drive from August 31st, 2016 to August 13th, 2017, when she then changed her voter registration to the Dana Avenue address. 4.5 years ago, she resided at that address. That the Democrat Party reports on its campaign finance reports after it received wire transfers that was her address. And then it identifies Xavier University as her employer, another false statement on their campaign finance report. So there was really 3 legs to the complaint. The source of money was not Murkowski, which I think is clearly established by the filings. 2, they provided a false address, and they provided a false employer. And in fact, what's even more shocking and amazing, when these contributions were made, who was the employer of Ms. Ruskowski? The Ohio Democratic Party. Their own employee was making these contributions that were not her money. Their own employee was reported with a false address. Their own employee was reported with a false employer. They knew who her employer was. It was themselves. And they hid that from the public. So I think there's clearly an indication of violations, multiple violations with respect to these 12 distinct contributions. I mean, there's still certain questions outstanding, like whose money was it? Were we getting money funneled through Ms. Ruskowski? What was the coordination? I mean, you get a wire transfer for $90,000, and the state party had no expectation it was coming, didn't know where it came from, just saw on the bank statement wire transfer from Ellen Murkowski. And that's all they did. There's more to it. So I would either ask for a violation today and a significant fine because of the magnitude of involved. And it's like, again, it looks like it's funneling money, where the minimum set up for hearing allow us to do the discovery that needs to be done to really ferret into this and to find out what's really going on with this money. I mean, you know, and again, the other thing I kind of said, I'll leave it at this is, you know, yeah, if I was a candidate and somebody contributed that money, I'd be doing, you look at she's not a usual suspect. Let's respect. There's certain individuals in the state who contribute significant sums to both parties. Ms. Ruskowski is a 25-year-old single woman employed by the Democrat Party, making $1,500 a week every 2 weeks. She clearly wasn't the source. They knew that. They should have known that. You know, blind ignorance, deliberate ignorance of their own records, of their own employee. It cannot be condoned by this commission. Thank you.
Mr. Huda?
Sure. So I want to quickly, Scott Ebay on behalf of the Ohio Democratic Party again. I want to quickly reiterate a bit about what we submitted in our affidavit and then say a bit more on top of it. The only information that we received when we received these wires said that the wires came from Ellen Murkowski. And the statement, the level of culpability, the mens rea under the criminal aspect, but under 3517.13 is knowingly conceal. ODP was never told that the money came from the Hamilton County Democratic Party. Now, obviously, a compliance mistake was made here. And, you know, your points on, you know, that Ellen Murkowski did not have the money, you know, that was never anything that was communicated at ODP. The only thing that was communicated at ODP was the wire information that we submitted as an exhibit. So yes, a mistake was made here, but it wasn't to the point where it was a knowing or even an intentional mistake. It was a compliance error. And so for that reason, I think we respectfully ask that this be dismissed. But beyond that, I want to also make a point on 2 different things. One is her address. So her address, that is information that she submitted to the Ohio Democratic Party, but years prior. So that was something that was told to the Ohio Democratic Party. That's where the state party got that information from. And it was sure it was from a contribution that she had made prior that was in her own name. But this got conflated with her other contributions because it said Alan Rakowski on the wire statements. So that's one thing. And then the other thing is she told us her occupation employer, and she stated as much in her affidavit where she said that she was a student at Xavier when I'm sure she made that contribution while she was a student there, and she accidentally said employer, but that's the information that goes to ODP, and that ODP will then use to report. Should that have happened here? No, there was a mistake here, but it wasn't a knowing or an intentional mistake, which is what the statute requires. So therefore, we respectfully ask, well, number one, that this be dismissed because it doesn't meet the standard under 3517. In the alternative, if the commission doesn't want to dismiss this, I would ask that we could continue this and see if we can get a clarified statement, which, by the way, number one, I don't think that we met the culpability level under 3517.13. But that is an aside. In Ms. Rakowski's statement, she talked quite a bit about how she used to work for the Hamilton County Dems and that she was like a signatory on their bank accounts, but she never actually says that the Hamilton County Dems sent the funds to ODP. And ODP has never received a donor letter, which we oftentimes receive from donors when the funds are coming over. So if she clarified that statement or added on to her affidavit or submitted a second affidavit basically stating, yes, these funds came from the Hamilton County Dems and were sent to ODP, we would amend our reports. And we would show those reports kind of under the framework that Commissioner Hagan was talking about under the previous case to show you that we did it. So in short, the only information that the team that was doing the compliance had was that the wires came from Ellen Rakowski. It's pretty clear the mistake was made. We're ready to amend our reports once we get the full information about where the funds came from. But there was nothing knowing as far as the concealment or any kind of knowing misrepresentation here. It was a compliance error, and we apologize for that. But nothing further from me.
If I may, on a rebuttal. Once again, here we are, quote unquote, compliance error. The problem is, Mr. Hubey said, and he gave me a heads up that, he assumes that this address, this false address, this false employer was premised upon prior contributions made to the Ohio Democratic Party. I did a search while here on the Ohio Secretary of State's website for contributions to the Ohio Democratic Party, to any political party, from a Rakowski. And the only contributions ever made to the Ohio Democratic Party from Ellen Rakowski were the 12 at issue. There were no contributions to the party in 2017 when she actually lived at Musketeer Drive. So the statement that it was the quote unquote the address that she submitted to the Ohio Democratic Party years ago is not accurate, with all due respect. I don't think there's any factual basis to support that. It's speculation, it's guesswork, and the records of the Secretary of State do not support that. So obviously, there's got, again, I think at a minimum we need to get more information. It's not continuing. Let's set it for here and we'll do some discovery, find out what exactly was going on at the State Democratic Party. When they get $444,000 and it doesn't put a red flag out there for anything. Nobody was on the phone to her saying, thank you for these contributions. What a wonderful person you are. They just went along and, another compliance error, and we won't worry about it. There's not best efforts. They knew where she worked. And I would assume that their HR department knew where her address, what her address was, because she was employed by the Democratic Party at the time these contributions were made. So again, we got the three issues, the contributions, what are the sources? They're clearly not recalcitrant. That's false. It's not a compliance error. It's a false report. They indicate the address. She even acknowledges she doesn't live there, and I would told you what the Board of Elections records indicate. 2016 to 2017 is when she lived there. It was a false report. And they identified her employer as Xavier University. Oh, she must be a professor or something at Xavier. No, she was a student back in 2016 and 2017 when she lived at that address. But this time when she made these contributions, she was their employee. It's not a compliance error. They're false reports on all three counts, 12 separate violations. Thank you.
I'd like to hear now from the.
My recommendation is to set the matter for hearing. It's got a lot of information that we don't know that presumably a hearing will bring forward. I respect Mr. Dubé's response and his, to a degree, an admission. Not exactly, but his statements made to the commission. But I just feel like the best approach for me, the best approach for the commission is to set the matter for hearing.
Mr. Chair, I move that we follow the recommendation of the executive director and set this matter for hearing.
Second.
We have a motion that's been duly seconded. Is there any further discussion, clarification, questions by any of the commissioners? Okay. Hearing none, all in favor, please indicate by saying aye.
Aye.
All opposed? The motion carries 7-0. The matter will be set for hearing. Thank you.
You're out there, I'm still here.
Yeah.
We could flip nameplates there, but just stay there, you're fine. Yeah, you got it.
An efficient trip from Cincinnati today.
Mayor, members of the commission, if you look at the second page of the working agenda and the ICW that I sent to you previously, case number 2022-R-427 was a referral that we received from the Hamilton County Board of Elections. The committee stopped the insanity pact, was accused for a late filing of their 2021 semi-annual report. The report was due on July 30. It was not filed until January 13th. You see my initial recommendation to the commission is to find violations and impose a fine of $150. That is primarily because the commission has not received a response from the committee. But Mr. Hartman is here on behalf of the committee. He asked for a continuance of this matter in a previous meeting. And so when we scheduled these other two cases for which he is the attorney for the complainant, put it on this meeting because he indicated he would be here and make a response on behalf of the PAC. So if the commission would so choose, we can hear from Mr. Hartman to get an explanation, and it may radically affect my recommendation.
Very good. Thank you, Mr. Chairman. Just a simple thing, as the indicated actually from the semi-annual report that actually was belatedly, well, that was filed in January. The commission can see that there actually were no contributions, no expenditures of the committee during that time. And because it says here on a violation of failure to timely file a semi-annual report, requirement actually under the law excuses filing of a semi-annual report if there are no contributions or expenditures. Section 3517.10. We're looking at. Looks like the 9th paragraph under A4 states that no statement under division A3 or 4, which is the semi-annual or the annual of this section, shall be required if the political action committee has no contributions that is received and no expenditures that is made since the last date reflected in the previously filed statement. So I believe that exemption does excuse the actual requirement to file, and therefore there could be no late filing of the semi-annual report. I would note, and I mentioned Mr. Richter prior to today's hearing, that does state that the committee, if that is the case, the PAC is supposed to file a statement to that effect. You don't have to file the report. You file a statement to that effect. It did not file that statement, though that's not the allegation in terms of the complaints. I would think it would be worth merit, at least at this on this complaint, to dismiss. Nonetheless, if the commission does look to proceed and find a violation and impose some fine, I would argue no good cause would exist not to impose a fine. Again, you're looking at a $300 bounce in this committee. It's an inactive committee, not doing anything. Just kind of, I think there's an outstanding loan that is kind of holding on to the purposes and principles of campaign finance disclosures are not being undermined by the non or the belated filing. There's no contributions, no expenditures. The public wasn't ill-served by the timing of this fine. So I would ask that if there is a violation, that good cause exists not to impose a fine. Thank you, Mr. Chairman.
Okay, Mr. Director.
Certainly based on hearing that, and based on the general directions the commission has given me, primarily looking at how late or how much distance between the original filing and the date the filing was originally or subsequently made, I would change my recommendation, find a violation, and impose a fine of $50. But I am respectful of Mr. Hartman's arguments for finding good cause. It would have been the first report that this committee, would have been obligated to submit, and certainly there can be confusion. So I'm sticking with my recommendation, find a violation, impose a fine of $50. But if the commission wants to do something different, I will certainly understand that and respect it.
Okay, your original recommendation was not reading the wrong thing.
Correct, it was, because there was no response submitted to
Okay.
the commission. But we have now received the response on behalf of the party, and so I think that needs to be respected. I am changing my recommendation, but am understanding if the commission decides that wants to go the next step further for
In your recommendation,
imposing a
is
fine.
$50.
Correct.
Okay, all right. Any comments or questions from the commissioners? Okay,
A question for the director. Can you just kind of remind me where our typical balance point is between good cause and $50? You mentioned it's the first violation, and so often has to do with like the length of time expended, right?
Right.
Filing. So kind of where on that spectrum does this fit, and why do you tilt to the 50 as opposed to 50?
Again, we're 2 years into kind of a change in thought and process on the fining process, because again, I go back to for an extended period of time, if somebody was before the commission for the first time, we would find a violation, but for good cause not imposed a fine, as long as the report was filed, regardless of time. I was given direction by the commission to change the approach some, shall we say. And generally speaking, what I'm looking at now is, if there is, if it's filed within a week, 2 week period of time, when the due date was, that's a good cause recommendation, timing. In addition, I'll also take into the nature of a response. In terms of whether somebody had some sort of a health issue or something else like that. And so I kind of take all of that into consideration. And certainly I am, like I said, not that I exactly get the nature of Mr. Hartman's presentation on behalf of this client, but we'll see those where there's confusion caused by the way the statute reads and so forth. And so I try to take that into consideration as well. But considering the length of time here, that's the primary reason why I'm recommending the imposition of a $50 fine. But again, if the commission believes that, based on their review of the circumstances, I don't know if I want to say confusion of the statute, because the statute says certainly no specific report is required, but you got to file something to tell the Board of Elections what your status is. And that was not done. Something wasn't done until January when it was due in July.
Thank you.
Sure.
So this pack is essentially defunct, is what I'm hearing. Is there a move to close this?
I think it's only because of the outstanding debt. That's really the only reason it's being held open is there's an outstanding debt.
What is the outstanding debt?
I'm not sure, it should be on the, I don't have the report that was filed. Actually, don't have the complaint. Second one.
It just shows $1,500. An outstanding, a loans owed $1,500 and a balance on hand of $337.09.
So I think the hope is to raise some money to get that loan paid off. That's really the extent. That's really the only reason it's being held open.
But all the board submitted was the statement or the front page of the report. And so if there is any further explanation as to what the nature of the loan is.
I was just asking, I was gonna make a recommendation. for the close, but for this business. Mr. Chairman, I move to accept the recommendation of the executive director.
Second,
The revised recommendation?
Yes.
Yes.
$50. Unless you want that.
I'm looking for the second. I'm waiting for the second revised recommendation.
Okay, there's been a motion that's been duly seconded. Any further questions or discussions on the motion? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, same sign. Seeing none, motion carries 7-0. Thank you very much.
Thank you very much. Thank you.
Been a day.
Safe travels.
Don got talking too much in that first case.
Thank you.
Thank you. Speaking of the first case.
As a senior in time, too.
I want you to stay, but you
Yeah,
never want to come.
yeah, you just want to switch.
I guess just give us, what is the problem?
He was supporting his college team.
No.
No, just.
Just like the Lord.
Yeah, no, I went to the same college you went to.
Right. Okay, now we go to the remainder of the group considerations. We have Right. We have one additional case, which is case number 2022 R-344. And in that case, the executive director recommends that we find a violation, but for good cause shown, not impose a fine. Mr. Executive Director.
Back to, this was continued, but it was like the day of the meeting, we got this response. So I thought I'd bring it back quickly, so I put it on this date. They were referred for failing to file a couple of mid-year reports, and the response that came in and the evidence included showed that, yeah, they were late in filing the 2020 mid-year report, but then in September of 2020, they filed a termination report that the board did not initially recognize or accept. But it, they demonstrated that it was filed. And so my recommendation here is find a violation, primarily on the failure to file the 2020 annual report, because it was about a week late. That's exactly what you were talking about, your questions before, Mr. Knight. But to find good cause, because otherwise the committee has subsequently been terminated. The report was only about a week late. I was glad to answer here the commission questions that the commission may have.
I'll move the recommendation of the executive director.
Second.
There's been a motion that's been duly seconded. Any further discussion? Seeing none, all in favor, signify by saying aye.
Aye.
All opposed, the same sign. Motion carried by a vote of 7-0. Okay. All right, other business, December 8th, The next meeting, Mr. Executive Director, what does the agenda look like at this point?
It is in serious question because that currently has the Blystone related cases on that meeting date. And so I am anticipating that something like that will get forward on that date, but I'm not sure if we'll be able to accomplish it, et cetera. But that is the primary thing. I think we have some other referrals.
It's Mr. Brown, right?
Mr. Blystone, we have. Do we have other referrals?
I don't, unless there's any reconsiderations or continued cases.
I think there's got, I think there's something else on that agenda, like some, it's like a case that come in, but the primary thing is, Blystone matters.
Okay, so,
So it could be a long game.
could be a long day. Okay.
It will be. Pack a lunch.
Latest thing here is like 3:30. No, yeah, be prepared to stay till 3:45.
I will keep you apprised of any developments that occur in the interview period of time. Needless to say.
Mr. Chair, I know it's still early, but what does the December 22nd meeting look like?
At the moment, we've got some referrals.
As things come up.
Okay, we've had some referrals, but I don't have anything else scheduled on there and was, I'm, in my own mind, was going back and forth on whether I wanted to schedule anything else in there.
Thank you.
So that's the best answer I have sitting here right now.
Was it in time for the carryover possibility of this Blystone case?
That's certainly one of the possibilities, yes. I mean, you've done that in the past where you can pull point where you can't go any further, just, pick something for the next meeting. But which is kind of one of the reasons why I've been sitting on scheduling anything else on that date.
Is there a requirement that, since we have new members, since we've had some of those hearings, I believe, do we need to provide transcripts of anything that's occurred prior to the Blystone matter to the new members?
I don't believe so, only because, all that was done there and going through things was to essentially set the matter for hearing.
We were all
And then
on those.
the evidence, there was one case of.
No, we got.
I think there was one that was heard like last December.
It's been a long
Yeah.
time.
Yeah.
Right, yeah,
But,
we heard the one in April or something.
yeah, but
Okay.
all we did, at that
No,
meeting,
that's
it
fine.
was a preliminary review where we set it for hearing. And so now the evidence presented at the hearing is what the nature of the commission.
I just wanted to anticipate any.
No, and I appreciate that. It is one of those things where if there is an appeal of the case, because that was a part of the commission's proceedings, that is sent along to the court. But historically, I have not presented any other materials. Leading into the hearing,